welcome to another newsworthy presentation from the International Cannabis Bar Association. We're an association of hundreds of lawyers across the world that provide the most up-to-date and impactful information to lawyers, professionals, service providers, business owners, and high-level managers at the intersection of cannabis and law. For attorneys viewing this video, learn more about the association and join today at incba.org. For a list of continuing legal education programs and access to a CLE-accredited version of this program, visit my.incba.org. For service providers and professionals, learn how the legal community can support your growth through our allied service tier of membership. For cannabis industry business owners and managers, there's no better place to find legal representation and to ensure that your lawyers are up to date than at INCBA. Learn more about our community and what INCBA can do for you at incba.org today. We hope Without further ado, I'm going to hand it over to our expert panelist, Jason Horst, our current president of INCBA and a lawyer here in the Bay Area. Randall Mayer, Adam Smith, Amber Littlejohn, three experts when it comes to interstate commerce. So we're really, really excited to have all four of you here with us today. I'm going to jump off screen. Let me know if you need anything, and I'm really looking forward to this discussion.
So I am going to take a very quick moment to set expectations with me at Interstate Commerce. I just happen to have a lot of really smart friends when it comes to the topic, and I am here to facilitate the discussion and learn just like you today. So again, as Chris mentioned, we have the pleasure of being joined by three of the thought leaders and brightest legal minds when it comes to this topic. Of course, we have Jason Horst, our fearless president here and the founder of, is it Horst Legal Counsel?
It is.
All right, fantastic. And then Adam Smith, as many of you may know from his work out west in advocating for access to interstate commerce through the, is it Alliance for Sensible Markets?
It is the Alliance for Sensible Markets. Nice job, Amber.
I'm doing it. And then one of my cannabis besties and my trusted colleague for my years in the trenches here in DC, Randall Mayer, who is the executive director of the Global Alliance for Cannabis Commerce and also a founding member of the Cannabis Freedom Alliance. So with that, gentlemen, let's get it kicked off with a little bit of background, because I know that we are going to be talking about all of these developments that are happening in interstate commerce. But one thing I want to make sure that we're setting a baseline on kind of how does interstate commerce, what is the lay of the land as it stands today, and how the federal government is playing a role here. What I'm going to do is I will just direct the question anywhere. And then I would actually, for the sake of the richness of the discussion, invite any of you to jump in and add to any of the comments made. So Adam, let's kick it off with you. So what is the lay of the land here as it concerns the states? And then Randall, I think I will lean on you for what's going on, a little bit of an insight on the federal side. So Adam, first with you.
So, without getting too deep into the history, everyone here, I'm positive, knows that we are operating under state silos and have been since, since Prop 215 in California passed in 1996 on both the medical and the adult use side. But in 2019, we wrote and passed a law in Oregon allowing the state to enter into a regulatory framework to regulate interstate commerce with other participating states, medical or adult use. And that bill, which got bipartisan support and was signed in 2019, had an either-or federal trigger. And it was either the state could enter into a regulatory framework, could begin to regulate commerce when the federal government either Congress changed the law, making it legal, which don't hold your breath, or the Department of Justice indicated tolerance through a memo or policy statement, which, as we know, is basically the permission slip that the entire industry has to operate a federally illegal, cannabis industry. So in 2019, that passed in Oregon, and we began putting a bill together in California to do much the same thing. Due to COVID and several other factors, that bill did not get introduced till 2022, but it was introduced in California this past year. Interestingly, when it was introduced, it did not have either of the two federal triggers in it. It just said California could do this. It did not require any indication from the federal government that this would be okay. There was some pushback legislatively on that point, and suddenly the triggers reappeared in the bill, but there was a third option. And so under the California bill, now the California law, the state can begin regulating interstate commerce the minute either Congress changes the law to make it legal, or the Department of Justice indicates tolerance through a memo or policy statement, or when the California Attorney General issues an opinion stating that doing so would not increase legal risk to the state. We also have a bill right now in Washington State which copies the Oregon law, which has the same two federal triggers. And there is a bill in New Jersey which copies the California law at this point, which gives 3 potential federal triggers. And on January 30th, Governor Newsom officially requested that opinion from the triggering opinion from his Attorney General, Rob Bonta. But he not only requested—
Going into that, Adam, I don't want to steal anyone's thunder.
All right.
We're gonna dig into that one in depth.
So here we are, we're at the cusp. And then I will leave it off to
So all of this feels really good. All of these wonderful, and we could do these things, and we have this opportunity. So Randall, I invite you to come in with a little rain on our parade and talk a little bit about these federal triggers and what is the status quo at the federal government level as it concerns interstate commerce and cannabis.
Sure. So from the federal perspective, there's 2 major operating statutes that govern how cannabis is treated in interstate commerce that are aside from the Controlled Substances Act. When we're looking at the interstate commerce questions, we have the Food, Drugs, and Cosmetics Act as well as a major federal governing statute. But we're also looking at the regulation under the Rohrabacher-Blumenauer Amendment, or Rohrabacher-Farr Amendment, the appropriations rider that deals with state medical programs. It's changed names a number of times over the years. Everyone's got a different memory of it. But that's kind of your operating framework. The Controlled Substances Act says no interstate commerce. And Gonzalez versus Raich has interpreted that to say no interstate commerce to the extent of no intrastate commerce, even if it affects interstate commerce based on the stream of commerce or the effects doctrine, which is a very broad, very wide exercise of Congress's commerce power under Article 1, Section 8. With respect to the Food, Drugs, and Cosmetics Act, that is a similarly broad preemptive statute that deals with the purity of products. And since there's approved drugs such as Marinol for THC and approved Epidiolex for THC, versions of that product which don't meet those purity standards or pharmaceutical drug standards can trigger Food, Drugs, and Cosmetics Act liability, depending on labeling, state practice, purposes, and approvals, essentially. But a number of companies have received warning letters from the FDA for putting CBD products in shelves in different stores and moving that across state lines. So that's one area also where there is some development that's occurring. The final big area is sort of the Rohrabacher-Blumenauer Amendment zone, or this Cole Memorandum zone. And the important distinction I want to draw here is that the Rohrabacher-Blumenauer Amendment is an appropriations amendment. It is not an exercise of Congress's commercial powers or Congress's other powers of Congress under its enumerated or implied powers. It is an exercise of Congress's tax and spend powers specifically. So as expenditures go through to the states, that rider, as has been interpreted by courts in California, prevents the DOJ from spending prosecutorial or investigatory resources that would interfere with state medical programs. And the breadth of those court decisions has allowed adult use to also be to grow in the same scope, because the DOJ can't investigate the difference between medical and adult use. It can't spend those resources. So the functional federal, what the First Circuit's referred to in the main case, the functional federal end of prohibition, as they call it, that is the amendment that people look to for what that meaning is. And it's important because it's not a functional law in the traditional sense. It's a restriction on use of funds for an existing mandate. So the mandate is created under the Commerce Clause, but the law that just slightly restrains it is under the Tax and Spend Clause. And that's just an important federal jurisdictional distinction.
And I think probably important to highlight the case that Randall referred to in the First Circuit, the Northeast Patients Group case that came out, and I believe in August of 2022. I think it was the day that INCBA had our last interstate commerce panel that Adam was on. The Northeast Patients Group decision, I think, came down the same day, and that case related to residency requirements for ownership in Maine medical cannabis companies, and the court there, applied what's called the dormant commerce clause, which is central to all of this interstate commerce discussion, in particular in the courts, and did not focus on what Randall was talking about, in that the Rohrabacher-Farr Amendment is not an exercise of Congress's Commerce Clause authority, which I think is an interesting distinction we'll get into later, but did say that, among other things, the Rohrabacher-Farr Amendment and the general limbo that cannabis exists in on a federal level gives a lack of clear authority, a clear authorization to states to discriminate against interstate commerce. And the way that these cases have been teed up generally has been related to residency requirements, and there have been challenges. And I see even some of the lawyers that are bringing these challenges are on this on our guest list here today. But there have been challenges to residency requirements in different contexts, whether they're statewide or particular social equity programs or city licensing schemes. And that's the way it's been teased out thus far. But all of that jurisprudence has direct applicability to what we're talking about here in getting to a point of interstate cannabis sales. The same legal authority is going to be highly relevant.
Well, I am no longer going to restrain you all. I see you biting at the bit to get into some of these cases. So I'm gonna put everybody out of their misery and let you get right to it. So let's first start. I'm gonna start right back with you, Jason. So tell us a little bit about that DCC letter that came out, that DCC letter to
the first stop on the West Coast Interstate Cannabis Tour. Yeah, so on January 30th, as Adam was mentioning, the Department of Cannabis Control in California sent a letter to Attorney General Rob Bonta, and the letter was related to that third prong that California inserted into its interstate commerce bill, asking for an opinion on the question, would California entering into agreements with other states to allow for commercial cannabis transactions between in-state and out-of-state licensees result in significant legal risk to California under the Controlled Substances Act? And what the DCC then did is make very clear, we are asking you a very specific question. We are asking, is there significant legal risk to the state under the Controlled Substances Act, which is in line with the language of the bill, but as I know Randall will focus on, there's a naked pregnant there, and there are things that they are not asking and not wanting the Attorney General to get into. And I think that is one of the more fascinating pieces of the article, of the letter. The other thing I will say is they don't just ask the question, they then go on in an 8-page letter to answer the question for the Attorney General in the affirmative, or in the negative, saying they will not present any legal risk to the state to engage in allowing interstate commerce by operators. And sorry, I'll let anybody else weigh in here to the extent you want, or I don't know if Amber, if you want to.
So I do have a follow, unless somebody wants to engage on the basics. I really, so what does that even mean? Does it change? How does that change the status quo? Because again, from a legal intellectual perspective, it is, again, it's fascinating, but what if anything does this do to the status quo?
Well, to the extent that the Attorney General agrees with the DCC, the California will be allowed at that point, the governor will be allowed to enter into agreements with other states to allow operators to engage in regulated interstate cannabis transactions.
So I'm going to direct Randall, the word allowed. When it comes to that, so what if the federal government just says, no, thank you? So what is the risk there, and where does the tension happen between the state and the federal government? Should the state of California and the state of Oregon and the state of Washington decide, you know what, we're doing this?
So it depends on the process, but essentially the Wickard versus Filburn and that line of cases and Gonzalez versus Reich is the most legally disadvantageous way we could be positioned in the Commerce Clause. Unfortunately, it's possibly the broadest line of cases from a power perspective that is deferential to the federal government's regulatory powers. So, for example, under the Compacts Clause in Article 1, Section 4, there's cases that say in areas of Congress's exclusive jurisdiction for the commerce power, you must have approval from Congress beforehand to do something. So if they do it under a compact, there's always still a risk that the DOJ could interpret it as saying, that's nice, but you need to go back to Congress before we'll lay off. There's also the risk that if they do it without an interstate compact, without some sort of this federal hook for that area, that the federal government could just choose to enforce its laws or remove the appropriations rider that stops it from enforcing its laws. And then the third category of risk, and these are all the parade of horrible risks that I can come up with. The third category of legal risk that can present itself is simply that the DOJ decides to try again on the question of what the meaning of the rider is when it comes to actual interstate commerce, because they can go into court and say, hey, we'll not argue the stream or the effects doctrine and get into intrastate commerce. We don't want to deal with that. But stuff crossing state lines implicates federal interests, and we have a different interest when it comes to actual interstate commerce. And that might be a compelling argument, depending on how it's framed and in which forum it is also put in. So the categories of risk kind of fall into those veins. That being said, those are also exclusive to operators, not the state officials.
and the DCC has expressly asked that operators not be considered in the opinion that they are asking the Attorney General for, right? And in fact, we talked about how the Dormant Commerce Clause is at the heart of all of this discussion. The DCC is expressly asking the Attorney General not to address the Dormant Commerce Clause, or for that matter, federal preemption in its discussion, and focusing on anti-commandeering provisions in the Constitution to focus on what is the liability of the state. And from that perspective, and I think the analysis is really cogent, and I encourage everyone here to read the 8-page letter, because we can't read it to you here, and we've got a lot to discuss. But I think it is correct that the legal risk to the state is genuinely minimal. Now, that doesn't mean that the legal risk to operators is minimal, but I think that the way that this is being teed up is at least an attempt to minimize the practical risk to operators, even if the legal risk remains high.
So
Look,
this is.
I was actually teeing to you. I want to tee up before you respond, Adam. I had a question specifically to you, and I mean, these are some pretty bold actions, and I want to get us to these other actions. But on the other side of that, the willingness of states to take action like this? You have been in the trenches all over the West Coast, Adam. What does this mean to you? How does this read for you in terms of the state's willingness to go to bat and to fight for existing industries in place on the West Coast?
So, Randall mentioned the line of cases from Wickard through Gonzalez v. Reich. And it's funny because he said it puts the industry in the least advantageous position vis-a-vis federal power. But interestingly, what Gonzalez v. Reich found was that everything that the states are doing now, medical and adult use, is already interstate commerce under federal law. They essentially said the minute, and the Raish case particularly was a caregiver giving product. I don't even think there was money exchange, giving product to a patient within a state, within the same state. And the federal courts found that this was interstate commerce. And so therefore, everything that the industry does right now is interstate commerce. And so the question really isn't a legal one, it's a political one. The Department of Justice is already tolerating interstate commerce in 40 states, right? And so the question, and the federal government has the authority, the DOJ has the authority to come in and arrest everyone now. Everyone involved in the industry could be arrested and would face massive prison time. And that is not happening because the Department of Justice has said it won't happen. And so the question is now, without a legal distinction, is there a line that the Department of Justice will draw politically to say we will tolerate this interstate commerce, but the minute two legal states decide to move product from where there is greatest supply to where there is greatest demand, the minute two states decide to regulate that, then we will step in without a legal distinction, but because politically we think that that is distasteful. And then the question comes down to, does the Biden administration or the Merrick Garland Department of Justice want to get into a fight with Democratic governors in particular, right, who are ready to take the next step in cannabis? And our working assumption on this is that they don't, and that is backed up by repeated statements from both the Department of Justice and the Biden administration that they are going to let the states make decisions with regard to legal cannabis. And so the only last thing I would add, I know we're going to move on, is that the move by Governor Newsom to not just ask for this opinion, but to write the opinion for the California Attorney General is a very aggressive move. And it does set up a situation where it's very apparent that Governor Newsom, at least, is ready to move forward. And there's such a desperate economic need across the supply chain, across the industry, to get the economics of this right, that I think we're going to see it happen.
Well, and I would add, the letter itself includes a footnote citing with approval to the Northeast Patients Group case out of the First Circuit, which some advocates may argue is a tacit admission that current law does violate the Dormant Commerce Clause.
So I'm going to put a pin in that, because again, I think I really do want to come back if we have time to talking about the political climate and some of the, again, sort of the federal risk hanging out there and tying it back in. But I want to make sure that we hit all of these and provide some overview on all of this. So Randall, taking us to Oregon. State of Oregon weighed in on the Dormant Commerce Clause just right after this letter came out. Can you tell me a little bit about the case and the motion to dismiss as it applies here to the cannabis industry? You're on mute.
I'm totally on mute. God, COVID. So the Jefferson Packing House case is a tee-up of a licensed producer that is trying to challenge the state's export ban, because Oregon does have a ban on exporting at the state level, in addition to the federal law, the Controlled Substances Act that we're discussing. So Jefferson Packing House wants to engage in interstate commerce is essentially the root of the case. Oregon moved to dismiss and took a very different position from what the Newsom administration's position in approving citations are too. They made their 12B motions to dismiss, one on 12B1 for lack of Article 3 standing, and then one under 12B6 for failure to state a claim. Now, the lack of standing argument asserts that a permanent injunction of Oregon's export ban is not a redress of the injury of interstate commerce, because there's still the federal export ban. Therefore, the legal status doesn't really change. My personal view, I don't know how much strength that has, because it's a difference between state and federal law, and state and federal exercises of police power. So, at least we're corrected from the perspective of Oregon state, but the federal ban still, under the failure to state a claim argument, Oregon at least articulates best here, I think, what the position is on the Dormant Commerce Clause and prohibition from those who are more on the prohibition side, or the more federal supremacy side, which is Dormant Commerce Clause cannot apply to protect a national free market among the states in a commodity for which Congress has declared there shall be no interstate market at all. And I've been reading through these cases, and I just think that sentence is the best articulation of the position, which is really an articulation of the inherent tension. Because the market, if all the doctrines and laws are being applied correctly, that doctrine should apply. But here we are in the state where the federal government doesn't enforce its own laws. It can barely be said to be actually moving on its own laws or its own supremacies. And then it's left behind all these vestigial Commerce Clause laws that could still potentially have a factor, have policy implication, and bring up a lot of these novel issues. So I just wanted to highlight that as something that I think was argued in Northeast Patients Group and in these other cases, and best articulates that position, at least.
Well, I think it's important to dig into the position you talked about, that they advocated for in their standing argument. To the extent, I mean, because to some extent, Oregon is essentially saying we can violate the federal constitutional rights of our licensees with impunity, because all of this is illegal under federal law anyway. And so you have no rights here.
It's like the opposite of 1983 claims.
And this is a state that has been a front runner in trying to expand interstate commerce. So it's a really interesting, it's really interesting, sort of juxtaposition. And I don't have insights on politically why that may be, but
Can I might though.
I thought you might.
So this case and the answer and the attorney for that case is here with us. The plaintiff's attorney, Andrew Deweese, is here. Hello, Andrew. But I think that it's important for folks to know that the moment that motion was being made for dismissal came at a time when there was a transition in the governor's office, during which time there was nobody in that office who was yet dealing with cannabis, and chaos in the OLCC, which is our regulatory agency, because a whole bunch of folks were reserving high-end bourbon for themselves. I don't know, many of you saw that, but there's the director was asked to resign and so forth. And so my strong sense is that the DOJ attorneys who were handling this case were left without any political guidance. And so the fact that their motion seems divorced, almost antithetical to Oregon's position on the broader policy goals, is disappointing, but I think not surprising. And I think that there is room as the case moves forward and folks on the political side get some traction on this, that the stance of the state might change for the better.
Good old adversarialism.
Fingers crossed.
All right, since I guess it just wanted to be exciting all in one big clump, or maybe it was a trend, let's move on to Washington.
Oh, sorry, go ahead.
No, please, go ahead.
Next leg of the tour, a week or two after the events in California and Oregon, Washington District Court came down with a dormant Commerce Clause decision that was a 180 on the First Circuit's decision in Northeast Patients Group. The case didn't involve a challenge to prohibitions on cannabis imports or exports, but was another case related to residency requirements. Washington has a requirement that you need to be living in the state for 6 months, 6 months before you can have a cannabis license. Someone came in and challenged that, and the court decidedly sided with Oregon, saying that arguments to the effect that cannabis has been substantially legalized at the federal level are nonsense, and holding that the Dormant Commerce Clause does not apply in the cannabis context at all. And I think that, in my mind at least, and I'm curious your thoughts, Randall, I thought that was a critical distinction that the court drew in the case. Was, the Northeast Patients Group decision analyzes the Dormant Commerce Clause issue and cannabis illegality as part of normal Dormant Commerce Clause jurisprudence. Has Congress Because there's an exception to the Dormant Commerce Clause where Congress has authorized states expressly to discriminate against interstate commerce. But the courts have required that that sort of authorization be express. And given the muddled nature of cannabis at the federal level, Northeast Patients Group says no express authorization. Brinkmeyer, the Washington case, treats this issue as a threshold question and says the Dormant Commerce Clause doesn't apply because cannabis is illegal, and it's nonsensical to try to protect, as the Dormant Commerce Clause tries to do, an interstate market for goods when those goods have been made federally illegal entirely by Congress. So
in this area of ambiguity, I'd say that Washington might not have the upper hand of the threshold issue. If I'm remembering some of this case correctly,
Yeah.
If I'm remembering, the Dormant Commerce Clause always applies. Where the Commerce Clause reaches, its dormant aspects also reach. There's some language to that effect about the scope of the Dormant Commerce Clause at the Supreme Court level. Like if the Commerce Clause reaches there, the dormant one reaches as well, unless Congress says otherwise, I think is how the doctrine is usually set up. So from that perspective, I mean, I think the question of the Controlled Substances Act and Schedule 1 presents is very unique in the sense because it's an exercise of the Commerce Clause power itself to create the prohibition. So the Dormant Commerce Clause as a doctrine ethereally applies, but what Congress's intent is not to apply protections. Maybe it's not to take them out. Maybe that's an implication that's a step too far, and it has some sort of novel judicial questioning to it. But as far as the protections against interstate discrimination, I think that's up a different kind of threshold question. So it's interesting because I think it does apply. I think the question is, now that it applies, when Congress enacts a prohibition on interstate commerce and something, does that say that states can enact measures based on non-protectionist reasons even that can discriminate against that interstate commerce? And I think that can collapse back into the criminal justice issue, which is more difficult to handle because we don't like limiting the federal government's criminal justice reach, generally speaking. But from the commercial perspective, on the other side, with that other initial question, if the Commerce Clause does reach there, then does it still allow striking down protectionist measures and support non-protectionist measures? Those are all novel, open, and really only unique questions to this area. So from the getting back to the threshold question issue, I think the threshold question, I think his answer is it does apply. The question is, how does it apply? Does it help or hurt?
Adam, before I pose a question to the lot of you, did you want to chime in on this point?
No, I would say that while I graduated law school decades ago and passed the New York bar, I've never practiced. And so to the extent I make the mistake of wandering into the deep legal weeds on this webcast, everyone should know that my legal analysis is worth exactly what you're paying for it if you're here on the membership rate.
So that's then you will be the perfect place for me to start because I want to kind of bring us back to collectively what this means. So from a political, I'm going to ask each of you pose this question to each of you, and I'm going to start with you. It's a two-parter. What does this mean? What does all of these events collectively mean from a political perspective? Mm-hmm. And what do you think it means from an industry and operational perspective?
So I think I think the letter, the memo from Governor Newsom to his Attorney General marked a new era in legal cannabis. The question is no longer, will states move forward to open up commerce? The question is, how will that happen and what will be its effects? If we look at, states around the country, there's two things going on here. We've talked about both. One is the political move toward opening silos up, and that would be a state opt-in, right? States would choose to participate in some multilateral regulatory framework. And then there's the legal question, which if it is found that the Commerce Clause applies, all of the silos could be torn open all at once. And so it's going to be interesting to see which way this goes. But I will say that we are in the process of misincentivizing massive production massive overproduction, and particularly in states where that production is never going to be economically competitive or environmentally sustainable. And when federal legalization happens, all of these silos are going to come down. And so I think, waiting for Congress to fix cannabis policy in the 30 years I've been involved in drug policy has never once been a winning strategy. It has always been the states that see the next step that has to happen and then either take it or get explicit permission, and the Department of Justice says, you know what, we're going to let you do that. And I think we are now on the cusp of seeing that happen. And I think it is going to be hugely beneficial, not just for producers in places like Oregon, California, Washington, but for retail, distribution, delivery, product development, manufacturing, wellness, and hospitality in states where the difference between having access to a dozen suppliers or 2,000 suppliers is life and death, and also for patients and consumers.
I can't, you said something that just made me absolutely have to ask you a brief follow-up question, because it's something that I hear over and over again. And you said it would tear open the silos that exist. Now, some people say that is not a good thing.
Right.
And so there is a lot of fear
Mhm.
as to how that affects existing and kind of future
Mhm.
markets. So I would love to just I would love to hear a little bit about your feedback on how you respond to that when people say
So
that.
we have been working specifically for 4 years to open up markets on an opt-in basis through a political process, right? Which would allow states to choose to keep their silos closed until such time as federal legalization forced them open. We think that that's a more orderly way to do this. We think that there are states that have, not just states, Washington, D.C. Is looking at a massive increase in demand, right? And nowhere to grow. Minnesota is a state where it makes very little sense to grow cannabis at scale. It's not going to be competitive ultimately, right? And so there are places where this is the smart thing to do and will support a viable industry that will be, much more welcoming to small business. It's just not the agriculture, right? And so, but then there are places where they want to keep that closed. And if we do this through a political process, states will be able to make that determination. If this happens through the courts, there's a chance that, federal court or the Supreme Court ultimately decides, hey, states can't stop this from happening, right? And there is a risk, at that moment, the federal government would still be able to step in and say, no, we'll arrest everyone, right? Because it doesn't change the fact that it's still illegal under the CSA. And so that would be the stopgap, right, to keep that from happening. But the courts could say that the states can't stop it. And we think that that's a potentially problematic, that might happen in a vacuum and could potentially be problematic in a lot of areas. And I personally rather see it be done on a political basis.
Randall, I'm going to go to you with my two original questions. What is the impact on the political climate? And then I will let our fearless leader here at INCBA wrap it up before we go to a few brief questions. So again, what is the impact on the political environment and then also potentially on industry?
So from on interstate commerce from an industry perspective, the siloing of marketplaces has probably been the worst thing to happen to cannabis and cannabis reform in the last 20 years. It has created cronyist incentivization for large companies that have limited license environments. It has created lobbying incentives and regulatory capture incentives that come along with that, to the detriment of small businesses or producers who can move across state lines. I've heard a lot the argument, oh, we should do regional marketplaces or something like that first. I mean, frankly, the United States is a regional marketplace. This is America. We're not creating some strange little regions of states or New England or whatnot to try to build up regional marketplaces that just compound the same climate and production problems from the same culture and same snow perspectives, frankly, because it's hard to grow in snow states. We all know that. That balkanization of the market has also led to a failure for the industry advocates and everyone else to actually come together and lobby for a comprehensive federal reform strategy. It's, frankly, it's not the Drug Policy Alliance. It's not Americans for Prosperity or any of those groups that are trying to not end prohibition. They want it ended as soon as humanly possible. They also want free commerce. The reason that, and part of the reason that we do that and that we allow interstate commerce is because it does build up provincial interest in exactly the way that we have seen as an industry have created problems with licenses and regulatory capture at the state level. The best way to break that up is federal preemption and federal disruption of that marketplace and allowing people to trade among states, because we don't need some 10-year transition period. I mean, frankly, we're not that complicated of a product. We're an agricultural commodity that's similar to wine. We can regulate that relatively easy and regulate interstate commerce. And that's also the political reality, because the federal government gets its tax revenues and its enforcement jurisdictions based on interstate commerce. So the notion that it'll waive its jurisdiction over interstate commerce or somehow devolve its power over interstate commerce back to the states doesn't usually serve the federal interest. Politically, what we've done and what Adam's done amazing work in doing is raising the temperature so that federal reform is more and more possible from an interstate commerce perspective. Now, politically, what that's going to look like is probably most likely free and open interstate commerce as soon as the rulemaking period is over for whatever the federal agencies are that will go with it. And in fact, that's what Schumer's bill and Mace's bill both say. So the leading proposals are already basically there and moving in that direction. So from a political perspective, raising the temperature and challenging these boundaries keeps increasing the odds that one of those bills gets negotiated through and passes, because essentially it creates a game of chicken with the federal government. Are you going to retain your powers over interstate commerce and taxation and revenue and jurisdiction, or are you going to surrender them? And the federal government doesn't like to give back power. It's a pretty fundamental truth of political history. So these moves are important for driving that progress. I think politically there's moves for people to try to keep state siloed marketplaces going. Frankly, I think those efforts are a complete waste of money and time because that's not how the federal government works or operates. But the political reality is towards descheduling or other incremental measures that affect sector-wide issues, not geographical issues.
Two stunning revelations from today. The federal government is not the best mechanism to legalize cannabis, and it doesn't like to give back power. So we have some really great questions that have been entered in the Q&A, and we also want to give folks that haven't necessarily entered one the opportunity to talk. So Jason, wrapping up this portion before we go to Q&A.
Yeah, I mean, I think
climate impact on the industry.
So, I'll add a legal climate and sort of how the case law is going to develop, issue on top of that, which is, I do think from the perspective of the extent to which any of this is resolved through the courts and, as Adam described, tearing open these siloed markets, which candidly, I don't think happens all at once. I think it happens state by state to the extent it happens because, each of these programs would need to be challenged one by one. And look, I'm here for it. But I think the way that the Ninth Circuit comes down on this issue, which is being teed up in the Peridot Tree case that is before it. I think it's getting there's briefing due tomorrow, I believe, in this case, on a residency requirement challenge. The way the Ninth Circuit comes down on the dormant commerce clause is going to have significant impacts on the political climate, because to the extent that the Ninth Circuit says dormant commerce clause doesn't apply to cannabis, it's going to throw a wet blanket on this as a strategy, because until it gets up to the Supreme Court level, the supply states that are mainly the West Coast states we're talking about, all these things happening in, are not going to be able to take advantage of it because they're in the Ninth Circuit. And so, in terms of, where that leaves us politically, I think ultimately you're going to move to a question of the how. How is product going to move from place to place? Because the answers to those questions are going to have major impacts on the political calculus involved, right? It's not just that you need to get through prohibition states. If you're a California operator trying to get your cannabis to New York, you got to get through Arizona and its licensed cap market, and its strong desire, almost certainly, not to have California cannabis flow through its borders. And so, I think that those are the sort of next questions is, at a nuanced level, how are we going to move product from A to B? That's going to have a lot, the federal government is going to have a lot to say about that, right? Do we get some kind of guidance in the way that Adam has been advocating for from the DOJ, some sort of a policy of non-enforcement on interstate cannabis sales that they put in writing, some sort of action from the federal government. But I tend to be in Adam's camp that waiting for the federal government, number one, is not a winning strategy, and number two, I don't think it's something that states like California are going to have the patience for.
Fantastic. I am going to, is it possible, if you don't mind, Andrew, I'm going to put you on the spot. Is it possible to give Andrew the ability to ask a question? Andrew asked a question in the Q&A that is a nice, good, solid, lawyerly paragraph long. So I am going to ask you instead to come on. And again, as you were one of the plaintiff's attorneys in this case, if you'd like to ask the question, just kind of, I'm sure you would do a way better job than myself summarizing.
Yeah, this is a pretty deep in the weeds, and thanks for having me, guys. This is a fantastic webinar and very timely. So, I'm deep in the weeds in preparing a response to Oregon's motion to dismiss, and so I'm thinking about these issues quite a bit. One of the main issues that I have with Oregon's motion and also the ruling in the Brinkmeyer case is that both of those folks seem to say that what the CSA does is eliminate any interstate commerce in marijuana. And I think that that's inaccurate in an important way. I think that the holding of Gonzalez versus Raich is that there is an interstate market in marijuana, and that with the CSA, Congress certainly expressed an intent that there be no interstate commerce, but it can't functionally eliminate it any more than you can eliminate the sun in the sky. So why I think that's important is that it brings the question and the case into stark relief. And to me, the question is whether or not whether or not the policy concerns under the Dormant Commerce Clause are served by allowing the states to engage in interstate commerce of this marijuana market, but rather whether or not the CSA expresses Congress's intent to allow states to pass laws affecting interstate commerce. And so I kind of just wanted to get the panel's take on that concept of what, what's the status of the interstate market in marijuana? Did the CSA eliminate it? Is that true? Or, how do you think, what's the real answer here, guys? What do you think?
I'll jump in. So Raich in dicta recognizes the existence of a widespread marketplace, but it does so for the purpose of affirming the federal supremacy to eliminate such a marketplace through the Controlled Substances Act, and specifically Schedule 1, as distinguished from the rest of the schedules, which contemplate a restrained but highly regulated federal marketplace under the DEA prescription scheme. The second complicating factor is the single convention on narcotics and the subsequent treaties. And I know we all have feelings about the treaties. I think they're ridiculous, and Anslinger really wrapped us up in a bind with those suckers. But the treaty laws, as they were passed and contemplated and interpreted by the State Department in the 60s and 70s and in the DC circuit in the normal cases, contemplates continued state regulation of cannabis as part of the federal cannabis scheme and the obligations of the federal government with respect to controlling cannabis. So if we take out all US law, all state law, local law, there's still bare treaty obligations to control and regulate any products that are made from cannabis and the research materials related to cannabis. Even the State Departments recognize that exists. And we used to be able to control that under actually, it was controlled under the Marijuana Tax Act of 37 originally, but then that was struck down in Leary, and then the 71, the Controlled Substance Act replaces it. And marijuana can only move so far around the schedules because the schedules are actually built around the requirements of the treaty to make it so that you can maintain a high schedule status for something you don't want. That's the Nixon administration's gift. That's all but a very complicated way of saying that RAICH carefully recognizes the market, recognizes the federal power to destroy the market down to the stalks of Wickard's wheat, and maintains the treaty obligations as part of it. Because, you know, it talks about, with the Congress being talking about the 9 states of medical use, the federal government still has the obligation to control the entire national market for the treaty scheme. And that's where their interests are limited and lie. So they can ignore substantial or insubstantial use in a state as in their discretion, but it's up to federal points of discretion under the treaty powers. So I think RAICH does a very careful job of balancing the fact that there's marijuana everywhere, and we're treaty obliged and federally obliged to not have that be the case.
But I do think that there is a common thread in the Brinkmeyer decision and in Oregon's motion of not fully contending with RAICH, and the fact that both RAICH and frankly the CSA, you know, treat intrastate cannabis activity, right, even a home grow in the case of RAICH, you know, as interstate commerce, and in no way distinguish between a home grow in your backyard and 2 tons of product getting shipped from California to New York. And so, at least in terms of blanket applicability of the exercise of the enforceability of the law. And so to say that what a prohibition on interstate sales is doing is stopping interstate commerce is inaccurate, right? You are creating a distinction that the CSA itself says you can't make, right? That there's I made sure to have this handy. 21 USC section 801, right? Is 5 and 6. You know, the CSA itself says you can't distinguish between intrastate and interstate controlled substances activity. And so because of that, I do think that you need to contend with that in the context of whether to and how to apply the Dormant Commerce Clause. And so I think that there is a thread that neither Brinkmeyer nor Oregon is pulling fully with regard to how RAICH and the CSA and their combining of intrastate and interstate cannabis sales to be the applicable interstate commerce that they are regulating. You know, that means that Oregon saying you can't sell product from one state to another does not actually serve the goals of the CSA, right? That they've fully regulated interstate commerce just within their own borders.
Fair enough, but I think that the RAICH court rejected that as the right way to frame the proposition. I think the notion that California law has surgically exercised a discrete activity that is hermetically sealed off from the larger interstate marijuana market is a dubious proposition, and more importantly, one that Congress could have rationally rejected. So from a rational basis review perspective, the reason Congress has the power to limit every stalk is interstate effects. So the court recognizes it's intrastate commerce. It's wholly intrastate commerce. It's entirely for personal use, but it changes the supply and demand side relative to the commercial sales in the market. And that intrudes on Congress's area of determination. So I think that it's exactly right, but that's—
you can't distinguish.
Yeah, but no, but that's why Brinkmeyer is very careful and why the courts are being very careful to make sure not to trip up the old rule that the Supreme Court retains the right to overrule its own precedent. So I think we'll see a lot of careful ways to represent this case crafted from lower courts. Was my overall point there.
And which is all why to me this remains a political question.
Mhm.
Right. This is all about what the federal government wants to enforce, will decide to enforce, agrees not to prioritize. Right. And that is how this has moved forward. It is what interstate commerce represents is an extension of exactly that. Without stepping into any new jurisdiction, right? What RAISH does is it gives the federal government jurisdiction over all of this. And it says the federal government has the right to stop any of this, starting with your homegrown. The minute you hand a joint to a friend, you are now engaged in interstate commerce and you fall under federal jurisdiction. And so because nothing changes, if you grow cannabis in Humboldt and send it to Los Angeles, or grow it in Humboldt and send it to New Jersey, right? It's the same penalties, the same crime, the same jurisdiction. Now we are engaged in a political push to get some assurance from the Department of Justice that they will stand up for exactly the policy. And it's not a written policy. We are operating without the Cole memo. We're operating simply under the say-so of Merrick Garland, that where folks are operating in good faith under state regulation, they see the DOJ sees no interest in interfering. And if they will just repeat that stance for the same act for interstate commerce, which is already happening, we can begin to open up and the cannabis market and take the economics of this, which has been stood on its head, and which I would argue has caused the vast majority of the suffering economically in this industry, why small businesses are having a difficult time, therefore why equity has a difficult time gaining purchase, why patients and consumers don't have access. The minute we can address that simple question, and it's a political act to say, we will tolerate this if you are operating under state regulation. And that to me,
but Adam, Andrew can't put that in his opposition brief. And I heard a rumor, Andrew, that you got extra time to file your opposition brief just so you could, have the benefit of having viewed this panel. Is that right?
That's exactly right. I knew this was going to happen, and I haven't even started, guys. I'm just going to take the notes from this and turn it right into the response.
And I will say to Adam's point, I think and it's a point Randall has made effectively in a number of venues, including here, protection for operators to actually start engaging, to the extent we have a state-based interstate commerce approach, protection for operators is going to trail protection for states, and it's going to trail state authorization of interstate sales and state regulation of interstate sales. And that will create interesting dynamics and winners and losers in who's willing to take the risks that people in this industry have been taking since 1996, and interesting legal ethical dilemmas for the lawyers who are advising them. It's definitely this is not a boring area of law, for sure.
No, it is not. You get to have really interesting constitutional debates. I mean, only in this area can you have any of this stuff come up.
It's just hard to get paid.
Yep.
You're not wrong.
So again, we have two questions. I have actually, let me make sure. I will have, if our staff can make sure to pull those remaining questions, we will actually send the answers to the remaining questions around to everybody, just to make sure that any questions you have gotten answered. Thank you again for everybody here. Thank you for taking time out of your day. To the panelists, Jason, Randall, Adam, thank you for sharing your insights with us and your wisdom, and definitely invite you back. Welcome to the party, Randall. We have a good time around here with our webinars, and I will turn it back over to Chris.
Yeah, no, I honestly, that was an incredible just period on the presentation with Andrew being able to hop on and ask a direct question, you know, considering the case that he's involved in at the current moment. So I really appreciate all of you joining us today and dropping all of this really valuable knowledge on our membership. So please do. I hope to see all of you at our in-person events that are coming up over the next few months. I will be
Including 3 more hours on interstate commerce at the Cannabis Law Institute in DC in June.
Yeah.
In there, all the dormant commerce clause you can take.
Maybe this might not have been the moment to threaten them with that, Jason.
We're trying to get people to show up to
Yeah,
us.
yeah.
Yeah.
We can get as
Marketing's never
dirty as
been
you
my
guys
strong
want to get. I love it. I absolutely love it. And we'll be in Randall's backyard. So maybe you can bring some of your federal government colleagues along to join the discussion. We'd love to see some of them there as well.
Yeah, Randall, you're on.
Well, ask Kathleen Sebelius and the NFIB to show up and have a debate.
I would love
it. Well, again, thank you again, and thank you to the International Cannabis Bar Association for providing, again, this wonderful opportunity to learn. So
Absolutely. Thank you all. And
Thank you, Amber.
Thank you, guys. Thank you, Amber.
And thanks for everybody who showed. That is great turnout.
Yep.